of that asset. Denise goes on to ask how long her ex-husband is going, or how long her current husband, excuse me, is going to have to pay alimony to his ex-wife. And the answer to this question really depends. And first of all, I should say that the term that most attorneys use for alimony these days is maintenance. Maintenance is a new term. It's basically referring to the same thing. But in terms of how long these payments are going to continue, in the state of Missouri, when maintenance or alimony is awarded to one party, the judge is no longer allowed under case law to put a date certain of when this is going to end on these payments. And therefore, the person who's paying them would need to come back into court to prove some sort of changed circumstances in order to modify their maintenance obligation. This, of course, would require the use of attorneys typically, and the incurrence of attorney's fees and court costs. And there again, there would have to be some sort of changed circumstance. If the ex-wife wasn't working at the time of the divorce decree, and that's why maintenance was awarded, and she's still not working, chances are circumstances haven't changed. Now, Denise also mentions that her husband and his ex-wife have a son together who is now 18, which brings up some issues of child support and emancipation, which there's another question that addresses this in more detail, so we'll get to some of those a little bit later. I'm going to move on to the next question now, and this question comes from Arthur. And this is more geared towards some child custody issues. Arthur has 2 children with his ex-wife, and they have apparently been going through a divorce process that that's seemingly fairly contentious because there's a custody evaluator and a guardian ad litem involved. Now, a guardian ad litem is typically an attorney, but doesn't have to be, but typically an attorney who's appointed to represent the best interest of the child or children, as the case may be, to the court. And they can do everything from home studies, meeting with the children, meeting with both parents, meeting with teachers, whatever they feel is necessary to make a recommendation to the court as to what will be in the best interest of the children when it comes to custody. Now, a custody evaluator is typically a third-party person who should be objective. In other words, they shouldn't really be involved with either side, although one side can retain an expert custody evaluator on their own, in which case they will be somewhat biased to the one side. The other side can retain their own. But if it's a custody evaluator who's appointed by the court, then typically they would be objective and unbiased. And they could do really a lot of the same things that a guardian ad litem would do to form some sort of opinion as to what would be in the best interest of the child or children. In this case, the custody evaluator and the guardian ad litem have both performed home studies of both husbands' and ex-wife's homes. Now, husband is saying that ex-wife has now moved from the apartment where the home study was conducted to another house, which he does not believe is appropriate to have the children. Basically, it's a home that is being renovated, and he also believes that she is cohabiting with someone who is on drugs. And he's asking if the judge should be made aware of this. Well, absolutely. I mean, if there is something like, if there is a possible cohabitant who's doing drugs, if there is a new home, which is going to help determine custody, if it's an inappropriate home, then certainly the judge should be made aware. Now, typically you wouldn't do this by picking up the phone and calling the judge and saying, "Judge, this is what's going on with my case." Typically, if you have an attorney, tell them, they should be telling the guardian ad litem, they should be telling the custody evaluator, they should be saying, "Hey, we need to conduct a new home evaluation for the home where mom's now living." Because obviously, if she's not living in the apartment anymore, then the home evaluation that they performed previously is no longer accurate. He also mentions that that the home is 3 bedrooms and 1 bath, and she actually has 4 children, a 10-year-old, a 9-year-old, a 2-year-old, and a 3-year-old. Now, granted, this is not really enough bedrooms to go around. It's not enough bathrooms. Whether this actually plays a part in the judge's decision, probably not. Judges typically, they're not going to punish a particular party because they don't have the money to afford, a 5-bedroom, 3-bath home. They're typically not going to pass judgment on those sorts of things. However, if it's a home where they don't have heat, they don't have insulation, they don't have food, they don't have basic necessities of life, that's a completely different scenario, and the judge certainly needs to know that before he makes a final judgment. I'm going to move on now to the very next question. This question comes from Barry, and he has a question about child support calculations. Gary is living in California, which I must admit I'm not incredibly familiar with California law, not really familiar at all. I'm certainly not licensed in California, and I'm not really sure how they conduct their child support calculations. However, he's asking whether you would use current income or you would use year-to-date figures, and there seems to be some issue as to the amount of money that a party is making at the time. Well, Barry, the way we do it in Missouri, if there is a particular party who is now making more and they're going to continue to make more, really the child support calculation should be based upon that figure, and it's based upon a gross figure that is annualized and then divided per month to determine a monthly gross income for that particular party. To address your question more specifically, or to give you a little bit better idea of how the calculation works, we do have child support calculators on DadsDivorce Live, DadsDivorce.com, that are per state and ask for certain data, which you can put in and get some sort of estimate of what your child support obligation would be. It's based upon the gross income of both parties. Again, it should be an annual figure, and it's based upon the number of children. Now, the California child support calculator also includes some figures for income taxes and federal withholding taxes, as well as pension and union dues, and other child support orders as well. So you might want to take a look at that. And again, that's DadsDivorce.com. You can go there, you can click on your state calculator, and you can determine a little bit better, some estimate of what your child support would be, and you just fill in the boxes and click submit. Now again, that's only meant to be an estimate. The judge would determine what the actual number would be, and but this would at least give you some idea of what you're looking at. The next question is from Mike, and he has a son who has just turned 18 years old, or will be turning 18, excuse me, and his son wants to move from his mother's house into Mike's house, and he's asking how much weight does an 18-year-old carry as far as the decision for custody go with the court, and what he needs to do in order for his son to move in with him. Basically, in Missouri, his son, is still going to be in high school at the time he turns 18. In Missouri, as long as his son is still in high school, or even if he's still, going to college at that time, he would not be emancipated, which would mean that the court would still have some sort of control over where this child lives, and would most likely base it on, in Missouri at least, would base it on the best interest of the child. Him being 18 does play a part, and certainly some judges will accept his opinion more than others will. Some judges will realize that from a practical standpoint, an 18-year-old is pretty much going to go where they want to go.